Good morning to everyone, dear organizers, Professor Szilágyi and Professor Vilec, dear colleagues, distinguished speakers, ladies and gentlemen. The title of my presentation is Freedom of Expression and its Restrictions in Europe. On the applicability of Article 17, I will focus on Article 17 of the European Convention on Human Rights to disinformation campaigns or fake news. As we all know, freedom of expression is one of the most fundamental values of a democratic and liberal state governed by the rule of law, and various international legal documents, including European Convention on Human Rights, ensure that everyone has a right to freedom of expression, and this right shall include freedom to hold opinions and to receive and impart information and ideas without interference with the public authority and regardless of the frontiers. So the freedom of expression has its active and passive aspect. And the European Court of Human Rights further developed substance and the scope of these rights. This article, as it was established in Observer and Guardian versus the United Kingdom and some other cases, applies not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb. At the same time, freedom of expression is not an absolute right. It could be restricted under certain conditions, and the exclusion clause of Article 10 stipulates that the exercise of free speech carries duties and responsibilities and may be subject to formalities, conditions, restrictions, and penalties that are prescribed by law and necessary in a democratic society. However, there are certain forms of expression that are not protected under Article 10 of the European Convention of Human Rights. Using Article 17 of the Convention, the Court has an authority to prima facie exclude some forms of expression from the protective reach of Article 10. Article 17 reads as follows: its prohibition of abuse of rights. Nothing in the Convention may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth herein and their limitation to a greater extent than is provided for in the Convention. This Article 17, by some commentators described as a guillotine provision, serves the purpose of preventing applicants to claim that the same convention protects their speech that undermines the very foundations of the convention. And in cases where the court establishes grounds for the application of Article 17, the three-step test enshrined in Article 10 would not apply. And this is in a way short-track mechanism for rejecting claims of alleged free speech violations that has been used to exclude hate speech from the protective function of Article 10 of the Convention. The first case before the European Court on Human Rights, where Article 17 was applied, was in 1957 case of the Communist Party of Germany versus Germany. By using Article 17 of the Convention, the European Commission rejected the claim of the applicant that their rights guaranteed under Article 10 had been violated and upheld the decision of a German Federal Constitutional Court to ban the party on the grounds that its program and activities aimed at the abolition of the democratic and liberal order of the state. And the Commission quoted Article 21, paragraph 2 of the Basic Law of the Federal Republic of Germany, that is about parties which, according to the aims and behavior of their members, seek to impair or abolish the free and democratic basic order or to jeopardize the existence of the Federal Republic of Germany, and such they shall be considered anti-constitutional. Basically, the Commission in this case found that the major political goals of the applicant, meaning establishing a social communist system by means of a proletarian revolution and the dictatorship of the proletariat, contravenes the fundamental values and guarantees enshrined in the Convention. Then the Commission applied Article 17 and then declared the application inadmissible. The purpose of this paper and this intervention of mine is to find the relationship in between the concept of fake news or disinformation campaigns and the application and the Article 17 of the European Convention of Human Rights. Fake news phenomenon itself has been described in the literature as spreading outrageous, distorted information to discredit opposition or create divisiveness between opposing groups. According to another definition, fake news is a false, often sensational, information disseminated under the guise of news reporting, and the European Union defines it as a verifiable false or misleading information that is created, presented, and disseminated for economic gain or to intentionally deceive the public and may cause public harms. For some commentators, the term is defined through the consequences it produces as the destabilization of the category of truth in a democracy with a geopolitical gain. In the context of the Council of Europe, and this is very relevant because today we will be addressing the relationship in between fake news concept and Article 17, was clearly clarified in a case of Brzezinski versus Poland in 2019. The case concerned a Polish candidate at local elections who in his electoral booklets harshly criticized local executives. This was referred to the domestic court that in very short time, in 24 hours, according to the special electoral legislation, found a violation of disseminating false information in the context of the elections and banned its further distribution. Mr. Brzezinski turned to the court in Strasbourg claiming that his rights under Article 10 were violated, and the court unanimously decided, under the simplified procedure provided in Article 28 of the Convention, that the applicant's rights of free speech were violated by the authorities. This case was very interesting because, inter alia, the court for the first time used the term fake news in the decision, notwithstanding the fact that neither the applicant nor the government did not mention it in their submissions. The court was subsequently criticized for using this term that was earlier found as inadequate and misleading both by the group of experts appointed by the Council of Europe but also in the European Union that also takes a negative stance on this term. When it comes to Article 17, I just mentioned the first case in which the Article 17 was invoked, but there is a line of cases, very interesting cases, that correspond to the prohibition that can be found in Article 17 of the European Convention, and these are cases of denial of genocide. Basically, the denial of some historical, well-established historical facts. And these cases, and I will just mention a few elements from two, in my opinion, two most important cases. One is Garodi versus France, and the other one is Perinček versus Switzerland, show inconsistencies in terms of interpretation of the well-established historical facts and inconsistencies in terms on the possibility of application of Article 17 to these cases. In Garodi versus France, there was a so-called genocide revisionist case. The court found that disputing the existence of a clearly established historical events, such as Holocaust, did not constitute historical research, but was rather an effort to rehabilitate the Nazi regime and accuse Holocaust victims of falsifying history. While denial and revision of the Holocaust undoubtedly fall outside the scope of protected speech, according to the court, the same does not apply to Armenian genocide. In case of Perinček versus Switzerland, the court concluding a three-step to determine whether the penalty that was imposed on the applicant for the denial of the Armenian genocide, he said during his visit to Switzerland that this is an international lie, in the course of criminal proceedings in Switzerland, violated Article 10 of the Convention. And the court concluded that his rights under Article 10 were violated because the necessity test indicates that the penalty imposed in criminal proceedings was not proportional to the legitimate aim in protecting the rights of others, in this case Armenian community. In arriving to that conclusion, the court took several elements into account, including the following. Mr. Perinček's statements bore on a matter of public interest and didn't amount to a call for hatred or intolerance, then there was no international law obligation for Switzerland to criminalize such statements. The interference with Mr. Perinček's right to freedom of expression had taken the serious form of a criminal conviction, and so on and so forth. What is interesting, though, is that in this case, in Perinček's case, the court didn't find it necessary to apply Article 17, as it was the case in some other cases, and to address the issue of whether denial of genocide in the Armenian case prima facie excludes protection under Article 10 of the Convention. However, what is indicative is that out of 7 judges who dissented to the majority, 4 of them stressed that the court failed by not applying this abuse clause and concluding in this dissent opinion that the court's approach to Article 17 has not been uniform. They reminded about 4 different cases in which Article 17 has been applied with the court. So, to sum up, as we can see, there are many intersections between Article 17 of the Convention and the concept of a disinformation or a fake news. Firstly, Article 17 applies in cases where alleged expressions are contrary to the text and spirit of the Convention. The drafters of the Convention aim to prevent the abuse of rights by those who propagate totalitarian ideologies, relativize mass crimes, particularly genocide, and systematically discriminate against members of national minorities. In such cases, the court does not need to determine whether a particular restriction on applicants' rights was in accordance with the standards under the Convention and its jurisprudence. Thus, it could be said that the Article 17 relieves the court from the need to assess the legality and the necessity of any individual restriction of the applicant's rights, free speech, by the national authorities by allowing to dismiss the application as manifestly unfounded. This is understandable and justified because such abuses of rights could jeopardize the viability of the Convention and the unique human rights protection system it establishes. At the first glance, it could be said that the same logic applies to the concept of disinformation or fake news. In its radical sense, this concept is per se contrary to all the values that the Convention promotes and protects. It is first and foremost the protection of human rights within the system of the rule of law of democratic states. These are the fundamental principles on which the regional organization of the Council of Europe, which recently marked its 70th anniversary, was created and further developed. Likewise, the abuse clause applies to states, groups, and individuals that correspond to the nature of the fake news that could be generated and disseminated by either of these subjects. However, it should be noted that not all forms of fake news are the same, nor all of them reach the threshold for invoking Article 17. Indeed, not all fake news is a threat to democracy. It goes only for those massive campaigns aimed at destabilizing the system, causing panic, creating confusion, and fueling social polarization. Likewise, in general, negligent and innocent fake news dissemination does not justify applying criminal sanctions. Finally, fake news could raise the issue of the responsible subject, given that the artificial intelligence very often generates them. Another relevant aspect is whether to distinguish fake news as untrue statements from other similar expressions, for instance, defamatory statements. The court has emphasized that a careful distinction is to be made between factual statements on the one hand and value judgments on the other. While the existence of facts can be demonstrated, the truth of value judgments is not susceptible of proof. However, shifting the burden of proof about the truthfulness of the statement to the applicant could sometimes face him with unreasonable, if not impossible, task. Since the measures taken by states in response to defamatory statements are not a priori excluded from exercising this three-step test under Article 10, there are no convincing arguments why fake news or disinformation should be treated differently. There is also a concern that should be taken into account that a priori exclusion of disinformation from careful juridical balancing under Article 10 of the Convention could undermine the role of the court, that is to provide interpretation in terms of legitimate aim as well as necessity and proportionality of the restriction in any given case. This is the clarification role of the court that is very, very important. Lifting this role by simply invoking Article 17 of the Convention in fake news cases might question simplistic approach to the issue and bring even more uncertainty in this field. And this is particularly important, having in mind not always consistent standards applied in cases that trigger the abuse clause, as we just saw in the cases of the well-established historical facts and the nuances in the approach of the court, as whether it was the case of Holocaust or some other mass crimes or genocide, as it was the case with the Armenian case. In other words, the threshold for using Article 17 has not been apparent even in cases that are considered a prima facie denial of freedom of expression, as the ones concerning hate speech, genocide denial, negative stereotyping of minorities, etc. So the nuances of the clarification role of the court in this regard were explained before, while comparing different approaches to various types of hate speech when it comes to the mass crimes, Gorodi vis-a-vis Perinček. With these uncertainties in mind, it seems that bringing a relatively new and not quite clearly conceptualized phenomenon and subjecting it to this control mechanism may not be a good idea given the imperatives of a legal certainty and of course, substantive justice. To conclude, notwithstanding the anti-democratic and anti-liberal dimension of some forms of fake news, particularly those integrated into large-scale disinformation campaigns that no doubt runs contrary to the text and spirit of the Convention, many valid arguments justify the caution when it comes to the blanket lifting of free speech protection mechanism provided in Article 10 of the Convention. Therefore, applying the abuse clause in the context of disinformation should be decided exclusively on a case-by-case basis, considering all the relevant arguments discussed in this intervention. So thank you very much for your attention, and please allow me to express my dissatisfaction, even a sorrow for not being there in Budapest with you. Unfortunately, for the reasons I explained to the organizers, I couldn't travel to Budapest. I was in contact with the infected person and I have to stay for a few days in a self-isolation. And at a moment, after consulting my colleagues, I decided to stay at home and not to travel to Budapest, not to put all of you in a risk. In any case, because I was really very much looking forward to meet you all in person, I really regret that I cannot be with you. But Professor Marta Dragičević-Pretenjača, who is a colleague of mine from the same department and who will, in case this project goes on, most probably replace me. I'm sure that she will very well represent our research team. Once again, I wish you all the best, successful conference, and please accept my warmest greetings from Zagreb. Bye-bye.